953801 was his cell phone number. The Section 205 records analyzed by Lieutenant Colonel Kusho disclosed communication amongst the accused in 2020. Exhibit DD5 in bracket, capital letter B in bracket. Do not disclose any communication between accused number 2 and accused number 4, Mr. Mapisa. There are no Section 205 records for the period of 2014, which were going to be central in this case in relation to the incident of the 26th of October 2014. Colonel Stein testified that this was attributed to the fact that a period of 3 years had lapsed when he did the analysis. The doctrine of joint possession of firearm. Joint possession of a firearm, particularly an illegal one, requires proof that more than one person intended to possess the firearm and that they did so together, not just that one person possessed it on behalf of a group. The mere presence of a group during the robbery where a firearm is used does not automatically equate to joint possession. Evidence must show a common purpose to possess the firearm, with either the actual possessor holding it on behalf of the group, or the group intending for one of them to possess it on their behalf. In State v. Nkosi, 1988, Volume 1, SACR 284W at 286, paragraph H to I, it was that held as follows: that this is justifiable in a factual evidence if the factual evidence exclude all reasonable inference other than A, that the group had the intention to exercise possession through the actual detentor, and B, the actual detentor had intention to hold the gun on behalf of the group. Only if both requirements are fulfilled can there be joint possession involving the group as a whole. In Makubela versus the State, Majeke versus the State, CCT 216 of 2016, also reported in 2017 ZACC 36, 2017 Volume 2 SACR 665 CC, 2017 Volume 12 BCLR 1510 CC, dated the 29th of September 2017 at paragraph 45. Quoting from the State versus Nkosi, 1988 Volume 1 SACR 284, capital W in bracket, at 286H2I, the court said the following, and I quote: "The issue which arise in deciding the group, and hence the appellant possess the guns, must be decided with reference to the answer to the question whether the state has established facts from which it can be properly be inferred by a court that A, the group had intention animus possidendi to exercise possession of the guns through the actual detentor, and B, the actual detentor had the intention to hold the gun on behalf of the group. Only if both requirements are fulfilled can there be joint possession involving the group as a whole and the detentors or common purpose between the members of the group to possess all guns." Close quotation. The Constitutional Court acknowledged that there will be very few factual scenarios which meet the requirements to establish joint possession. This is because of the inherent difficulty in proving that the possessor had the intention of possessing a firearm on behalf of the group. Awareness alone is not sufficient to establish intention of joint possession or possessing a firearm, or the intention of holding a firearm, or the intention of holding a firearm on behalf of the group. Whilst common purpose can be used to prove possession by the group, it is not sufficient on its own to establish joint possession. The state needs to prove beyond reasonable doubt that the accused had intention to possess the firearm either personally or through another member of the group, and that they had the ability to exercise control over it. The evidence of Sergeant Manda Richard Masondo. Sergeant Manda Richard Masondo testified that he is a member in the South African Police Service attached to the Provincial Tax Surveillance Unit, which is the sub-unit of the Provincial Organized Crime Unit. He testified further that on the 9th of February 2015, he was on duty during police investigations in the company of his colleague, Sergeant Lamin. While on duty, he received an information about a suspect he was looking for. As a result of their investigation, a 9mm Czech Republic loaded with 15 rounds, live rounds of ammunition were found, and one ammunition was on the chamber, and a blue box with 12 live rounds of ammunition with different caliber in a room allegedly occupied by accused number 3. They proceeded to Cleveland Police Station to open a case of possession of unlicensed firearm under Cleveland Case 96 of 2015, SAP 1386 of 2015. The firearm was sealed in evidence bag number FSE 385083. The evidence of Lieutenant Colonel Christian Mangena. Lieutenant Colonel Christian Mangena testified that he is stationed at the ballistic section of the Forensic Science Laboratory and employed as a forensic analyst. On Monday, July 2020, during the performance of his official duties, he booked out an exhibit firearm and ammunition at Cleveland Police Station under Cleveland Case 96 of 2015, SAP 1386 of 2015. The exhibits were received in an open evidence bag number PA 400810-885 and were booked out for further investigation purposes as per Phosphorus Case 636 of 2014. On the 27th of July 2020, the exhibits, firearm and ammunition were booked back at Cleveland Police Station, sealed in evidence bag number PA 400-440-4332. On the same day, the exhibits were booked out at Cleveland SAP 13 store by Brigadier Geninda. Lieutenant Colonel Mangena testified that he compiled the report in terms of Section 212, subsection 4, small letter A in bracket, and 8A, small letter A in bracket, of the Criminal Procedure Act 51 of 1977 as amended, Exhibit X 13 in bracket C in bracket. He recorded his findings at paragraph 9.1 of his report. The cross-examination of Tumelo Madlala. Mr. Ramsepele asked the following question, and I quote, "And then also, could you tell if the farm had a wheel on the side, something that looked like a wheel or a rotating object on the side?" Madlala: I looked it, like I have already said, that I did not take a lot of time to observe that particular firearm, but it looked to me as though it was a firearm that had a wheel on it. You find this on the transcribed record dated the 8th of August 2023, page 6, lines 16 to 22. Advocate Mnisi posed the following questions to Mr. Madlala. Thank you. But now this one, a distinctive feature of it, it looked like there is a wheel. Mr. Madlala responded in the following respect. Yes, I have already said that, yes. And when I looked at it, I saw it from the front portion of it. Close quotation. They were said, Watermeyer J.A. in R. vs. Blom, 1939 AD 188 at 202 to 203, two cardinal rules of logic that could not be ignored when it comes to reasoning by inference. 1. The inference sought to be drawn must be consistent with all the proof facts. If it is not, then the inference cannot be drawn. The proof facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. If they do not exclude other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is the correct one. Thus, From the evidence of Tumelo Madlala during cross-examination, the proved facts of the ballistic report cannot be the only reasonable inference to be drawn, as they do not exclude every reasonable inference to be drawn. Then there is doubt whether the inference sought to be drawn is the correct one. The test for joint possession of an illegal firearm is well established. There is no independent evidence that accused for participated in the murder and the subsequent robbery, or that he was part of the conspiracy to kill the deceased. The state did not prove beyond reasonable doubt the inference that he had intention to exercise possession through the actual danger, and that the actual danger had the intention to hold the firearm on behalf of the group, except what is contained in the confession statement of accused number 2. In terms of the 5 principles I've alluded to, enunciated in the State versus Mkete's decision, that is the presence at the scene, awareness of the attack, intention to make common cause, active association with the attack, intention to kill the deceased or to contribute to his death, I find none. It follows, therefore, that the state has failed to establish a prima facie case in respect of counts 4 and 5 of the indictments, and to this end, he must be acquitted. Conclusion. It ought to follow that if a prosecution is not to be commenced without that minimum of evidence, so too should it cease when the evidence finally falls below that threshold. In short, my Lord, what I'm submitting in my heads of arguments is the following: that there is no evidence tendered by the state upon which this honorable court may convict accused number 4. The onus is not on the accused person to prove his innocence. It has always been the duty of the state to prove the case beyond reasonable doubt as far as 1961. It is not the duty of accused number 4 to go to the witness box and supplement the state case in any way, or incriminate, or by so doing, incriminate himself. For the aforegoing, I submit that the accused that is accused number 4 be acquitted and discharged in terms of the provisions of Section 174 of Act 51 of 1977, dated at Pretoria on the 15th of August 2015. Thank you. 2025. Thank you, my Lord. Thank you.
Yes, sir.
As you could, please, my Lord, we ready to start with our submissions. However, the fact of the matter is that we will not finish this afternoon.
Yeah, so?
The question is whether should we start and then continue tomorrow, or just continue tomorrow?
What's the view of the other
in other words,
councils?
commence tomorrow.
What's the view of the other councils?
My view, my Lord, is I think it will be, the interest of justice will be best served if we start the submission by our colleague on a clear mind, my Lord, because we also need to concentrate. We have overly concentrated today. I'm afraid if we were to start another chapter, a new chapter in this application,
Okay.
we might miss a factor or two,
All right.
as we are noting down, my Lord. Thank you.
Yes, Mr. Ramsapiri?
This is my Lord, I do concur with Advocate Munesi that we should start in the morning, my Lord.
Thank you, my Lord. I have no objection to the request to start
What
tomorrow
is the
morning.
request? Because
To
we are
roll over.
finished.
To roll over.
No, I'm just joking.
Yes.
Yeah, and Ms. Nishodo?
No objection, my Lord. We can roll over until tomorrow.
Yeah, in the meantime, this court, in terms of Section 186, I haven't yet made a final decision, but I think in the interests of justice, it would be fair to to record the evidence of Mr. Makela. Is it Mr. Makela, the gentleman who was at the garage? Allegedly at the garage.
No, but he's passed on.
Yeah, I know that. That's
Yes.
why I'm saying 186.
Yes.
Which section do we normally use?
Is
I
it-
know it's evidence rules, section 3,
Yes.
1988.
Yes, that's.
Yeah, in the interest of justice, when you want to call a witness like this, because as Mr. uNxumalo was arguing, making submissions, I'm thinking that this witness, allegedly, he saw something. According to Ginanda.
Yes, Mr. Makaleni.
Makalenia,
Yes,
and
yes.
Ginanda is the one who took
His statement.
the statement from him. Are you aware of that case?
Yes.
State versus KLB. It's in Britain, 1983. But it was used in South Africa by two judges, Sishi and Madondo. Are you anybody aware of that case? I can bring it tomorrow.
Yeah.
You've never heard of that case,
Yeah.
Mr.
Well,
Ramsepi?
Never had one.
Yeah. So what he did is, there's a case in Britain which some of our courts in South Africa have used. This gentleman was charged with rape in Britain. And he was subsequently, after being charged, he died. He died. But the detective who took the statement from him was still alive. And the full court in England ruled that because this evidence may be useful in trying to sort out this very case before the full court there, we can listen to the evidence through the investigating officer. The only proviso was that the investigating officer should have
for once-
sworn in this witness and told him what is the effect and the difference of adducing evidence on a statement under oath and what are the consequences if you are lying. You remember that?
Yes, yes, yes.
That's it. And it was allowed, that case, on that basis, that it would be in the interest of justice to listen to this evidence through the investigating officer, because he is the one who contemporaneously took the statement of the deceased. Like in this case, it's Geninda who says he took the statement.
No, I think it was taken by someone else.
Is that so? It's not
Yes.
Geninda.
No, it's not Geninda.
Just check for me.
Yes.
Okay.
No, it's definitely
Everybody
someone
can
else.
check for us, so that we must see whether it's a waste of time or not. So you say it was taken by somebody else?
Yes.
Who? Mohani?
We'll just get
Mamfundisi? Who?
hold of the states.
Who?
We just want to verify now, but
How
our
many
recollection.
investigating officers were there?
Yeah. Yes, the court will recall that there were different teams working on this
Oh, by the
matter.
way, yeah, okay, fine.
So it was taken by the
Possible.
team that
Oh,
was
all right,
involved
okay.
right at the beginning.
Okay, fine. Okay, let's meet tomorrow then. We'll check that.